As the 1st of July 2021 gets closer, EU residents in the UK are getting more and more anxious. The High Court has rejected a legal bid for an extension to the EU settlement scheme, the EUSS. We might have left the EU, but there is still a lot to deal with. If you are an EU or EEA resident in the UK and have not yet applied to settle yet, you need to watch this video. I am Kareesha Turner, your human rights barrister on Kareesha Law. From the 1st of July 2021, EU, EEA and Swiss citizens living in the UK without having applied for pre-settled or settled status under the EU settlement scheme will be here unlawfully. That day is coming soon. Those with pre-settled status will need to make a further application in order to upgrade to settled status. The Home Office has provided a guidance, I'll say a useful guidance, to reflect the EU-UK withdrawal agreement or the Brexit agreement. It's a helpful guidance, and in certain circumstances you may be able to apply late if you have a good reason for it. And this is all in the guidance. There are people who have a biometric card or residence card issued under the EEA regulations. They will not be able to rely or use them beyond the deadline. Not to work, not to be here. The hostile environment will now extend to EU nationals living in the UK, which means that EU nationals could risk losing their jobs, access to benefits, and be subject to removals and so on. Lately, however, I have noticed the Home Office issuing EUSS refusals, particularly refusals to grant EUSS status or refusal to grant pre-settled status. I will not be covering invalid or withdrawn applications today, but I want to talk about something else. The Appendix EU provides two reasons to refuse an application. Firstly, on a suitability basis, that is based on the person's character or conduct, which makes them unsuitable to be granted status. We see that a lot in deportation cases. Or secondly, on an eligibility basis. That is, if they failed to demonstrate that they are eligible for a grant of status. Now, within that category, you can break it down further. Number one, failure to show UK residence, or failure to show, for a non-EEA or Swiss applicant to show eligibility through a qualifying relationship, either in the past or in the present. This means that if you are claiming that you're entitled to the grant of indefinite leave under the EUSS scheme, the applicant must prove that he was a UK resident before the end of the transition period, or that he or she is related to an EEA or Swiss national and show the relevant evidence. If you fail to provide this, you will be refused, just like under the immigration rules. It is your responsibility to prove this. It is not good enough to say, well, the Home Office had the documents or is aware of or was aware of. For EUSS applications, after the end of the grace period, if the holder cannot prove that they have been in the UK for 5 years, they will be refused. Now, what about paper applications? I'm aware that the applications are done online through an app, but in my experience, a paper application process is generally reserved for more complex EUSS applications. So if you have made an application online but receive an email from the Home Office asking you to prepare or to submit a paper application, or that they wish to speak to you about your application, it is wise to contact a lawyer before doing so. How about and how do you go about challenging a refusal? Well, there are many ways of doing so to challenge an EU SS refusal. It depends on the reasons for which you have been refused, and that goes without saying. Generally, for a suitability refusal, the only way to challenge the outcome will be to appeal to the court. This will include deportation cases, etc. Again, I have seen people make fresh applications after a deportation refusal. Now, this is not a very good idea, as what will happen is the Home Office will simply repeat the grounds of refusal and suitability, so that's not a very clever way to go about it. Some cases will attract or may attract an administrative review. Again, you will need or require a lawyer to deal with this. If you have received a refusal based on lack of evidence, depending on the wordings of the refusal letter, you may be able to apply again with the correct evidence this time. Or if you have applied for settled status but receive an incorrect status, this can also be challenged. There are thousands of EU or EEA nationals who are not aware that they need to apply. If you have lived here for 5 years and have pre-settled status, I will encourage you to apply now, although you may be able to apply, and you can apply certainly after the expiry of your pre-settled status. There's no limit to that. We will start seeing a lot of refusals, including refusals for people who have come here before we joined the EU in 1971 or before 1971. I will do a video on this in the future. Also important, very important, update your contact details with the Home Office. Again, that goes without saying. The EU settlement scheme is the biggest scheme of its kind. Apply now if you are eligible. If you or your friends have any questions, I specialise in European law, contact me or contact a lawyer who can help you. We are in a period of transition, but this will end soon. And it's important that people realise that. It seems some people are slipping through the net only because they have been here for a while and think that everything is going to be okay. You can apply online. It is a fairly simple or straightforward application if you have the evidence or if your immigration history is straightforward. Good luck and thank you for watching Kareesha Law.